Hi, thank you for joining this week's Paralegal Power Break. Now, if this is your first Paralegal Power Break, they're short, information-packed sessions that provide information and resources specific to the paralegal career. So in today's Paralegal Power Break, we're going to discuss Ediscovery rules and process. Now, Ediscovery is huge. It's a huge body of information, so it's impossible to even scratch the surface of Ediscovery, even the rules, in this particular session. So what I'm going to do in this particular session is first just start off explaining what Ediscovery is if you've never heard of it, and then I'm going to discuss some specific rules that are really important as far as Ediscovery, and in those rules it will explain the process of Ediscovery, and then I'll at the end wrap it up by providing an overall Ediscovery process for a paralegal, and what a paralegal would do in an Ediscovery role. So what exactly is Ediscovery? Ediscovery is the abbreviated term for electronic discovery. So Ediscovery refers to any process in which electronic data is sought, located, secured, and searched for, using it as evidence in a case. Ediscovery is also known as EDD, electronic discovery. In the process of electronic discovery, data of all types can serve as evidence. Examples of electronic data include text, images, calendar files, databases, spreadsheets, audio files, animation, websites, emails, voicemails, and computer programs. This particular definition was taken from U.S. Legal's website. So to provide a real life example of how Ediscovery would come into play is if you're working, let's say you're working on an employment discrimination case. In this case, a client, you're representing the plaintiff, and the plaintiff is saying that they were fired because there was some discriminatory treatment against individuals that were in their particular class, whether that, race, age, a protected class. So Ediscovery would come into play when your firm is requesting emails that may discuss some of this treatment. Maybe people that were in this particular class, let's say older individuals, were discriminated against as far as the type of work that they were assigned to, and there could be some emails circulated from management which details what the different individuals were assigned to. And this would prove that individuals that were older were assigned like the very minimal accounts, for whatever reason that was done. So just giving an example. But so emails would be accessed. Ediscovery would be accessing these emails, even databases, like wherever the employees, in this particular example that I get, whatever systems they worked on, maybe there was reports that were generated to show which cases particular employees worked on. That's a part of Ediscovery. If there's any intranet sites which shows, how many cases or projects employees worked on, their notes, whatever the case may be. Voicemails, maybe your client has voicemails from a manager providing some information that would help in the suit. That would be Ediscovery. Audio files, anything that is electronic in nature. So you just keep them. If you have a familiarity with discovery process, there's interrogatories that are saying questions. request for production of documents, requesting documentation in a case. Ediscovery goes beyond this type of discovery or accessing or requesting information to determine the facts of the case and to obtain evidence by specifically addressing electronic information. Anything that's in electronic format that can be used as evidence in a particular case would be considered e-discovery. And there's a whole process that is used for obtaining that information. There's several different phases where this information has to be obtained. It has to be obtained, it has to be collected, it has to be reviewed, it has to be analyzed, it has to be placed in a proper format. These are all different phases or steps in e-discovery, because it's not like, sending an interrogatory, which are questions that are being sent to individuals in a case, where you just type some questions out, mail them, email them, whatever the case may be, and that's the process. That's it. E-discovery requires so much more, because you have to be familiar with different programs, formatting. All those things have to be handled correctly, where if you're just working on interrogatories, requests for production of documents, a deposition, you really just have to know, what questions are you going to ask, and record, like if you're in a deposition, recording that out, reporter present, or if you're sending requests for production of documents, sending it over. E-discovery, you have to have computer knowledge. You have to know so much more than just asking some specific questions. So I'm going to go over some really important rules regarding e-discovery. First is the meet and confer. This is really important. This is Federal Rules of Civil Procedure 26F, which clearly states that as soon as practicable, attorneys are supposed to get together and try to not only try to settle the case if they can, but they have to discuss the issues related to electronic discovery. What format is the information going to be placed in? Preservation of information. All that information is discussed during the meet and confer. It avoids confusion later on when someone says, well, I didn't know you wanted it in this format. And this is why we provided it in this format. So it has to be, the information that's in electronic form has to be submitted in a totally different format, or it's argued in court that it's going to cost too much. It avoids all those particular issues. Another rule is the duty to exchange and preserve electronically stored information. This is Federal Rule of Civil Procedure 26A1B, which states that the parties need to provide, without awaiting a discovery request, a copy of or description of the category and location of all documents, electronically stored information. So pretty much they have to disclose the description, all relevant information, anything that is going to be pertinent to that particular case, that's going to be later discoverable or requested, or through the correct process and procedures for obtaining that information. Then you have Federal Rule of Civil Procedure 26B2B, which is the duty that if there's an undue burden or cost for obtaining some information, it doesn't have to be disclosed. If it's not reasonable, if the cost is too much to be able to provide this information, to access it or put it in a certain format or whatever the case may be, then it doesn't have to be, disclosed or handed over in that particular format, or whatever is causing is the request that's causing the undue burden or cost. And then you also have Federal Rules of Civil Procedure 26B 5B, which is the clawback rule, which states that it provides a process for a person that inadvertently discloses information to get that information back. So let's say, for instance, you're sending an email to your managing attorney. Let's say you're responding to an email was sent from opposing counsel to your firm, and you respond to the attorney. The attorney uses that as the email to tell you, okay, they're responding to this email, but they're sending it to you saying, do we have this piece of information or whatever? And so you respond back and you hit the reply all. So instead of it just going to the attorney in the firm, it goes to opposing counsel. And let's say you attach something that was confidential or privileged. The clawback allows for, it's a rule that allows for this information that's privileged to be returned, and it doesn't waive the privilege. And then lastly, we're going to discuss, before we wrap it up here, the safe harbor provision, which is Rule 37F of the Federal Rules of Civil Procedure. And it states that a court may not impose sanctions under these rules on a party for failing to provide electronically stored information lost as a result of the routine good faith operation of an electronic information system. So that pretty much says if information was destroyed in a regular routine process that's done in a company or whatever the case may be, then that particular party will not be sanctioned or fined for destroying that, because they didn't do it. It wasn't done maliciously. It wasn't done purposely. It was done in a regular process of destroying or removing information from a server or whatever the case may be. If you're cleaning your emails or whatever is routine, or the company goes through routine practices to remove information off of their servers to make more space or whatever the case may be, there won't be sanctioned if something was destroyed that may have been able to be used as evidence if it was not done with a malicious intent. It was just done during the regular process of conducting business and the way that the company usually handled this type of information. So I'm going to wrap this session up. I know it's a lot because these are different rules. You're going to have to go and look them up to get more information about them, because I just provided really like a synopsis, and even a synopsis of Ediscovery and the Ediscovery process. But the session is meant to provide you with a foundation, a starting point, where you can use this information in this session to do some further research if you're interested in learning more about Ediscovery, or if Ediscovery is a part of your job. Because as a paralegal, you can position yourself as an Ediscovery paralegal, and that's all you do, which is great because right now there's a huge need for professionals with both legal knowledge and experience and Ediscovery knowledge or experience. So you can learn more about Ediscovery. Go to a good website to go to is www.aceds.org. I believe it stands for the Association of Ediscovery Specialists. So you can Google that if that's not the correct website. It's been a while since I went to it, but there's somewhere where you can start to get more information about Ediscovery. So hopefully this session was helpful, and I hope you have a great rest of your Wednesday and a great rest of your week.